Let me talk a little bit about probates and why they have such a bad name. Probates have a bad name because of what you hear in the media. What comes to light are those situations that are terrible situations. Number one, it was a bad estate plan. Or number two, it was a bad will or no will. I had a very crazy probate involving Kitty Oaks here in Spokane County. And one of the reasons it was such a terrible probate is there was no will. And because there was no will, and there's a lot of other things that added into it, the attorney's fees were quite high. There was 4 attorneys involved. All of that could have been solved easily had there been a will, which there wasn't. So probates are given a bad name because you hear about those. You hear about the high costs. With a situation with a good estate plan, a probate can be a very efficient process to an orderly administration of the estate. Yes, it's going to cost money. You can try doing it, a do-it-yourself probate, but I can tell you that it's very rules-driven based. You do this, you do that, you give notices, you do this, you do that. And, if you're trying to do it yourself, the likelihood is you're not going to get very far. A lawyer who's done many of these is going to be able to do it quite efficiently. However, whenever you're talking about legal fees, you're talking, legal fees will easily run in a probate $3,000 to $10,000 to give you a sense. That's in Washington State. In California, it's based on a percentage of the estate, and that's why people in California want revocable living trusts. Here, though, in Washington, probates will cost money, but sometimes it's a really good idea to do a probate. One of the things about probate, too, I wanted to mention is that if you want to protect assets for your spouse when you're gone against long-term care costs, the only way our state allows you to do it is if you have a will, you probate it, and a trust is created through the probate for your spouse. Again, that's a topic for another day. With revocable living trusts, people are not likely to even seek out legal counsel. And so what that means is that the trustee who's trying to carry out the terms of the trust, once the trustor is gone, is deceased, they may do it right, they may not do it right. And so the result of that will be there could be litigation that arises from revocable living trust. Just because there's a revocable living trust doesn't mean there's not a forum for somebody who's aggrieved by the successor trustee and what they're doing. They certainly can file a lawsuit. So a revocable living trust by no means guarantees that there won't be a fight and angst and legal costs. It all depends on how good was the estate plan? Was it set up right? Did you select the right person to carry out your wishes?